Yes, my lords and my lady, I'm getting close to the end of my submissions, but I just wanted to try your patience by just turning up Yamaguchi one more time. Tab 12, the supplemental bundle. And if you recall, at the top of 186 on the left-hand column, there was a reference to a number of known beta-3, selective beta-3 agonists. And these were beta-3 agonists in rats. And the 177A was performed poorly in humans. That was common ground, probably not necessary to turn to documents. But that's the comparator that's used in the patent in suit, 177A. You see that in the second line. And then we just very briefly just remind you of the key passages under therapeutic potential for drugs, that the in vivo effects of beta-3 agonists on bladder function have been studied in animal models. Relaxation of rat detrusor is known to be mediated not only by beta-2, by beta-3. And then there's a discussion of the types of experiments that are recalled in the patent. So you've got bladder relaxation, and then you've got cystometry, and so forth. And then and they were all done in rats, of course. And then just at the bottom, it was, although these results are encouraging for the clinical development of beta-3 agonists for treatment of overactive bladder, beta-3 agonists have already been used clinically. And then there's a reference to the diabetes work. And then my lords and my lady will recall in the middle of the next paragraph, it says these studies indicated pharmacological differences existed between the rat and the human. Indeed, all of the beta-3 agonists tested in the clinic to date are only weak, partial agonists of the human beta-3 receptor and are not selected for the human beta-3. And defining a treatment for overactive bladder may therefore be dependent on the development of beta-3 agonists that shows selectivity for the human beta-3 receptor. So that was the what the art was waiting for. And then the conclusions. Human beta-3 AR appears to be a useful target for therapy of overactive bladder. So the common general knowledge, and I don't think there's any dispute about it, was that the human beta-3 agonist appeared to be a useful target for treating OAB. And you have seen the cross-examination yesterday where the witnesses accepted that human selective beta-3 agonists had potential for use in therapy of OAB, but there was a need for human selective beta-3 agonists, as explained in the paper. And we say that once 6 human selective beta-3 agonists are disclosed, it is obvious they have potential for use in therapy. And what the patent contributes, or what it purports to contribute, is perhaps what I should say, is that it identifies in the prior art a human selective beta-3 agonist. And the prior art it identifies that in is the patent document 1, which is the Japanese equivalent of 288, 288 being the Australian. And it suggests using this to treat OAB. And the tests it performs are routine and obvious tests, and it's the testing, the type of which is referred to in Yamaguchi, and we'll come on to the fact that that sort of testing doesn't actually tell you anything about activity in humans.
Mr. Turner, I'm sorry to start off with by being so slow, but why have we gone back to Yamaguchi? What does the reread add? What do you
well, partly it's regrouping, but it's really the key thing explaining that the rat studies were different, were of limited value and were routine. I'm just reminding my daughter that. I'll explain my lady of that. I'll explain why this has become relevant in a moment. So the testing performed in the patent. So what the patent does is it goes to the prior art, says, look, here's a human selective beta-3 agonist. It does this routine testing in rats, and we say in these circumstances the patent is prima facie obvious. And had the judge not attached weight to the lack of clinical trials he would have found it obvious. And let's put this another way. What is the technical contribution of the patentee? What has the patentee contributed to the art? Has it identified a new beta-3 selective, human selective beta-3 agonist? No, it has not. That is old. Has it disclosed a new use for beta-3 agonists? No, that use was part of the common general knowledge and is described in Yamaguchi.
Potential use. Does it make a difference?
On the facts of this case, no, it doesn't. No, it's a potential use, so it's an obvious use. And then we come on to the uncertainties and the ACES tech point, which I'm going to come to in a moment. So all the patent does is identify a potential use, and all the prior art does is identify potential use. And how much emphasis one puts on potential, we'll come back to. So has it contributed anything material? Has the patent contributing anything material to the art in terms of clinical trials or the testing of mirabegron on human tissue to determine its potency and selectivity? The answer again is no. Has the patentee offered any new theoretical insights? No. So the question then arises, was the judge entitled to rely upon these perceived problems which the patent does not address? And this is the ACES tech point. And I addressed you yesterday on the fact that the judge, in his analysis of obviousness, placed weight on the general clinical uncertainty as to beta-3 agonism as an approach, and we saw that most clearly in paragraphs 195 to 198 and at the end of 202. This is the perceived problem or perceived uncertainty which the patent does not address. I also addressed you on the perceived problem that mirabegron may not be a potent and selective beta-3 adrenoreceptor agonist. 288 teaches that mirabegron is a selective human beta-3 agonist, but does not disclose its potency at the human receptor and does not test it on human bladder strips. This is something the learned judge relies upon at 199 of his judgment in the analysis section. Again, this is a perceived problem, lack of potency, which the patent does not address, lack of potency at the human receptor. All the patent does is it just cross-refers to the Japanese equivalent of 288. As to the rat assays disclosed in the patent, these do not inform as to the potency or selectivity of mirabegron. As a matter of common general knowledge, it was understood that potency did not read across from rats to humans. You have seen that in Yamaguchi. You've seen the warning as part of the common general knowledge in Yamaguchi. And yesterday, I showed you the cross-examination of Dr. McMurray, day 4, 361 and 376, where he confirmed that. There is also a finding of the judge to this effect, which is at 86, paragraph 86, 7. The rat and human, so 86.7, the rat and human beta-3 adrenoreceptors differ materially in their pharmacology, such as agonists which were selective for the rat B3 adrenoreceptor were not full agonists of the human receptor. So. Now the judge acknowledges the ACES principle at paragraphs 34 and 35 of the judgment. But when he comes to his analysis, he does not apply it in respect to the issues that we're addressing. He apparently clips its wings because of Connor, and we say he was wrong to do so. So that takes me back to the relationship of Connor and ACES and the court's questions yesterday. Now, we accept that obviousness has to be judged by reference to the claim, which is what Lord Hoffman emphasised. We submit, however, that that principle lays perfectly, properly alongside the ASUS-TEC principle. We should have a look at the claim in this case. The claim is set out, sorry I didn't go to it yesterday, I should have done. It's at 138 of the judgment. So it's a remedy for use in the treatment of overactive bladder comprising mirabegron or a salt thereof as an active ingredient. So it's got a use component, it is used for treating overactive bladder.
It's completely immaterial, but I'm very puzzled by the statement in 139 that it's a second medical use claim. It is a medical use claim.
This is a medical use claim.
And in fact, it's a first medical use.
I think that is
It doesn't really matter at all. It seems very puzzling.
I think that was a submission made to the judge by Mr. Wyand at one point, but my lord is quite right.
Yeah.
I don't think it matters,
No, it
but it is a correct observation.
Doesn't matter at all.
Now, in addressing the obviousness of this claim, cannot be permissible, we say, to rely upon the general uncertainties which the patent does not address. And I invite you to consider the following example. Assume, slightly different to this case, actually not that much different, but slightly. Assume Dr. Barron, in 2000, as my learned junior, being the smart chemist that he is, published that mirabegron is a human selective beta-3 agonist, and in the same document stated that it's suitable for use in treating OAB. And he gives the recipe for how you make mirabegron. Now, if the ASUS-TEC principle did not apply, the next morning, Astellas could apply for a patent for mirabegron for that use. And when Dr. Barron stands up and challenges Astellas and says, look, you can't patent this, it's obvious. And they would be entitled to say, well, Astellas would be entitled to say, no, well, you see, it's all very uncertain. And we are entitled to a monopoly because it's all very uncertain. And they have done absolutely nothing other than just write down and patent what Dr. Barron had published. That would, if that was the law, that would, in my submission, be an unfortunate result. And why is it not the law? We say, well, because of the ASUS-TEC principle. And that is not a million miles away from what is happening in this case. Of course, the use is part of the common general knowledge, well established in the common general knowledge. We're not talking about something peripheral. The use of beta-3 agonists and mirabegron has been published as a human selective beta-3 agonist. So how does this mesh with Connor? And let us go back to Connor and look at the claim. That's tab 5. And the claim, we looked at it before, is at the top is 717. Just ask you to remind yourselves of it. There was a stent, angiogenic factor, an eluting stent with a polymeric carrier, and the anti-angiogenic was Taxol, if you recall.
Yeah, you directed our attention yesterday to claim 1, but actually the claim that was the subject of the argument was claim 12.
Yes. Yes, for treating or preventing recurrent stenosis. In this case, there had been a significant contribution to the art. There was a new plausible approach to treating restenosis, which was to use an anti-angiogenic, though this was a novel idea, and it was a plausible idea. And then there was the identification of a highly potent anti-angiogenic, which had been identified by the CAM assay, which we had looked at. So the learned advocate, Mr. Thorley, what he did was he put the claim to one side, and one sees that in his analysis at 15, or his submission to the court of paragraph 15. And he says, he doesn't refer to the claim at all, he just says the invention was the idea of trying something. Sort of 3 lines, the invention thus lies in the idea of trying some one or more Taxol polymer combinations. This was an unusual and, in my submission, a brave submission in that case. And there's no precedent for it of which I was aware. And of course, the court said, no, you have to ask the questions by reference to the claim. But the court is not saying that an ace of stec objection could not have been taken. So what would have been the ace of stec objection in this case? Well, looking at claim 11 or claim 12, it could be articulated in a number of different ways. You could be saying that the patent has contributed nothing to the treatment or prevention of recurrent stenosis. That case wasn't put quite like that, but if it had been,
Well,
then the court would have said...
we can see what the argument was of paragraph 18.
Paragraph
18 in Lord Hoffman's judgment, where he points out that Mr. Thorley sought to avoid the question by watering down the claim invention by reference to what he said were inadequate in the specification. It did not contain information about human or animal tests,
Yes.
which showed that it would work or provide enough information about doses and so forth for an escape person to work it. Nothing more than an idea that Taxol won't work, and any skilled person would have known that. And the argument for the respondent in the present case is that that's precisely analogous to your argument before us.
Yes, but of course that could have been, he could have said, as my lord is rightly pointing out there, look, you've contributed nothing, patentee has contributed nothing to the problem of whether this will work. And in that particular case, the answer would have been, well, yes, we have. Of course we've contributed. We've contributed.
Well, yes, but look at what Lord Hoffman says at paragraph 22. It is true that the specification said very little about the details of how or why Taxol would be efficacious in preventing restenosis.
Yeah, but it had...
It saw the solution, but offered no proof that this was right.
But it had offered, it had made a technical contribution. So
To be sure, in the CAM assay.
Well, and the theory. The theory, the novel
Well, there
theory.
wasn't any theory. It was a completely untested proposition. It was actually speculation.
Well,
And they proved to be right. It was speculation. It was genius. It proved to be correct. And they had some experimental data in the CAM assay that Taxol was the one to use.
yes. So it was plausible speculation. That's important.
To be sure.
Plausible speculation. And
Yeah.
it was based on a rational theory.
Yes.
And, of course, in another court, in another day, another judge might have said that was too speculative. But that wasn't this case, and that point wasn't taken. But there was a material technical contribution both in that theory and in the identification of Taxol as an exceptional anti-angiogenic.
Yep.
And so on the facts, it's very different to this case. On the facts, it's very different because it had contributed something. So as soon as you'd articulated the ace of step question, notwithstanding the learned judge's caveats at being about proof, but if you had articulated the ace of step question, which doesn't require proof, it requires, has the patent contributed anything? The answer would have been yes. And had it been put in the ace of step way, which it wasn't, it was put in this very odd way by Mr. Thorley, with respect to Mr. Thorley, the argument never fell that way. If it had fallen that way, certainly by the time it got to this stage of the case, of course it would have been said, well, no, the patent does contribute. If it contributes enough is a separate question, and that sort of comes under sufficiency. But remember here, our case is very different. We are saying that in respect to the issues in which the judge is concerned, clinical uncertainty, the patent has contributed nothing at all. And they were not concerned with the narrow question of clinical uncertainty in Connor in the same way at all. So Connor was an odd case on the way it was argued. It was an odd case on the fact. The principle from Connor we absolutely say should be followed, which is that you look by reference to the claim, and that sits alongside the ASUSTEC principle. If one then wants to get sort of down and dirty, if I can put it that way, and start comparing the facts.
Yeah, I mean, I don't think it detracts in any way from your argument, but while we're on Connor, I think we ought to look for completeness of paragraph 37, because that's the paragraph that's usually cited, because that puts quite neatly the basic point in the case, which is that in that case the specification offered a theory, anti-angiogenic properties as to why Taxol will prevent restenosis. It didn't offer any evidence this would turn out to be true. If it hadn't turned out to be true, the patent would be insufficient. But then we get the key statement of principle. No reason as a matter of principle why, if a specification passes the threshold test of disclosing enough to make the invention plausible, which in that case was uncontested, the question of obviousness should be subject to a different test according to the amount of evidence which the patentee presents to justify a conclusion that his patent will work.
Yes. So there was a novel. It was a novel approach, a novel theory, a novel way of treating restenosis. One can, and in this way, in this case, we just don't have that. Because the use of beta-3 agonism to treat OAB was in the art, part of the common general knowledge. So we don't have that. That's the major difference between Connor and this case on the facts, is that in Connor there was a whole novel approach. It wasn't part of the common general knowledge to use anti-angiogenics. It was entirely new, it was inventive, and it passed the plausibility test. Here we have nothing new and necessarily nothing inventive in terms of the approach. And so the sole thing that's differentiating patent from the prior art are the matters we've discussed. I don't need to repeat them. So then turning to my Lord's question, that was the question I was trying to answer rather badly yesterday, my lady's question on Connor. Turning to my Lord's question about prejudice, in our submission there's no formal requirement to engage ASUSTEC or Pozzoli. There's no formal requirement as to prejudice. There's not a lacuna. Lord Justice Jacob was not intending to limit his observations to cases where there isn't a formal established prejudice written into the textbooks. And after all, his observations were being made in the context of a case about whether CDs would essentially scratch each other if they were put next to each other in a box, although the argument was unsuccessful. So any perceived...
Yes, that's not quite, wasn't quite my question. So let me restate
Sorry,
it. And I hope to make myself clearer. The Pozzoli is addressing a scenario where the patentee seeks to rebut an allegation of obviousness by saying there was a prejudice in the art. And that brings in Lord Justice Jacob's analysis. What I find odd about the reliance upon that line of authority in the present case is that it doesn't seem to me, and this was the intended subject of my question, that at trial Astellas ran any such argument. I don't see any trace in the judgment of an argument to the effect of, oh, there was a prejudice, and that's why it wasn't obvious.
Well, I think they put it as there was pending clinical trials, there was enormous uncertainty as to whether this would be successful.
But that's true in any case involving human medication. What makes this one different?
It's not for me to say what my learned friend's submissions. I think he would say it's a little bit different because it hasn't been tried with any beta-3 agonist. But that's a fine distinction. I accept my. Yes, I mean, if we say it's very easy, and it goes back to my example with Dr. Barron. If you say mirabegron is a beta-3 agonist, and beta-3 agonists are useful in treating OAB, that's straightforward obviousness. Bang, it's an old idea. And one doesn't, and I'm now having to deal with a judgment, and indeed arguments are put before the judge, that no, that doesn't apply because of general clinical uncertainties. And those general clinical uncertainties are ever present. They're present in the prior art, they're present when the patent is published. So why is the patentee allowed to...
If one analyses this in terms of obvious to try, which there is a hint of in the judgment, although it's not really analysed in that way, as we all know, obvious to try doesn't get you home unless you've got a reasonable expectation of success.
Yes.
So is it your submission that one disregards the question of whether there's a reasonable expectation of success?
No, I don't think... I mean, obviously, it's reasonable in the sense that the prior art is suggesting it. It's not an unreasonable expectation of success. Reasonable expectation of success, of course, just shifts the question a little bit as to how reasonable is reasonable. And we're in danger of coming full circle. But I think we have relied on the fact that it's obvious to take mirabegron forward with a reasonable expectation of success. Of course we did, and we did below. But we say it's much simpler than that. It's an old idea. Mirabegron is old, and this is where it does sort of fit in with what Lord Justice Jacobs is saying. Mirabegron is old, and the concept of using human selective beta-3 agonists to treat OAB is old. One sort of, the idea is old. And that is, in our submission, what Lord Justice Jacob was analysing in Pozzoli.
I can understand, I think, the argument that there might have been a reasonable expectation of success for the class.
Yes.
But on what basis do you say there was a reasonable expectation of success for mirabegron?
Well, on the basis that it's described as a human selective beta-3 agonist.
That's it.
Yeah, and then it comes, because those were the compounds which were expected to treat OAB. And again, there's where we bump into the second point. Yeah, I mean, a note's just been passed to me. I think it's a good point. Reasonable in this context. Sorry, my lord, I'll come back to reasonable in this context has to be contextualised with respect to sort of success rates in clinical trials. Otherwise, all medical uses would be inventive. So one's asking, and I think we've even got in the bundles, the requirements for patentability don't normally require clinical trials to have been performed in normal circumstances. But in this case, and going back to my lord's question, in this case, we rely on the fact that mirabegron is disclosed as a beta-3, human selective beta-3 agonist. That is old information. Insofar as there really were question marks about its potency, again, it's the same point. The patent doesn't address that. So the patent doesn't measure the potency. All the patent does is point to it. It's like my example with Dr. Barron. All the patent does is point to mirabegron in the prior art and go, there you go, use that. And then there's of course the rat assays, which we're going to come to in a minute. So if any perceived problem or deficiency in the prior art will do, then the patentee becomes a beneficiary of something he or she has not invented. And that is why Lord Justice Floyd used the word perceived problem. And the perceived problem in this case, lack of clinical trials, if that is not a perceived, lack of clinical trials is not a perceived problem, ACE's tech is not engaged, and the patent is obvious anyway.
Yeah, well, I think we've got that point.
Yeah. Okay. So, my lords and my lady, we do invite you to revisit obviousness in this case. And we say the patent is obvious for the following reasons. And just very briefly, because I think I've said most of this already, mirabegron is old, it's disclosed as a human-selected beta-3 agonist. Common general knowledge that beta-3 agonists have potential to treat OAB. The claim must be obvious, it's that simple. The rat testing, insofar as that is relevant at all, was routine. It's testing which was described in the prior art. It's of limited utility and does not address the problems that Astellas rely upon to justify the patent. The experts did not really dispute that it was worth taking a human-selected beta-3 agonist forward. You saw that, Professor Mills, 326, line 21 to 25 yesterday, accepted the beta-3 agonist had potential for use in therapy. It's reproduced in the judgment at 180. And Professor McMurray, 392, which we've looked at, accepted that a beta-3 agonist would be taken forward into testing with rat and human detrusor. One thing we haven't seen, we looked at some of the cross-examination, was Dr. Argentieri, which is at, I think, tab 14, the supplemental bundle. Last reference. I just invite you to read paragraphs 117 and 118. And you've seen stuff I referred to yesterday, so I didn't realise it was in the bundle. My lords and my lady, you've seen the cross-examination that we looked at yesterday, which is the passage where he said, the witness talks about not waiting until everything is laid out nice and tidy and getting ahead of the competition, which we say does not really engage the substance of this evidence. Finally, and this is the very last, I mentioned in opening that Professor McMurray had explained that the difference between the rat and the human. So in the human, it was predominantly beta-3, unclear whether beta-2 played any role. In the rat, it's both beta-2 and beta-3, which is another relevant factor. And I referred to the evidence. I gave you the evidence reference, but I realise the page is not in the bundle. Can I just hand it up?
Okay.
Was it Dr. Argentieri of whom the judge said that he had the impression that some of his report was written by lawyers?
Yeah. That's the witness, yes. I don't think it's that aspect, but
it's just that reading paragraph 117 brought that observation to mind. That doesn't make any real difference.
I think it's. I mean, writing expert reports in patent actions, as my Lord Justice Arnold has written a judgment on, it does involve
more than
questions
one.
are artificial. Requires a measure of toing and froing, which is legitimate, whether it was. But that was the cross-examination, and I just wanted to show you what the cross-examination is based on.
Thank you.
I think it's Here it's 5.6. I just referred to yesterday. If I could just invite you to read that. This is Dr. McMurray's second report.
Yeah.
My lords and my lady, unless I can be of further assistance, those are my submissions.
No, thank you very much. Let's try.
Use your lordship's ladyship. Could I start by taking Ausestec, which is in the supplementary, the authorities bundle, tab 10. Page 310 of the bundle. Paragraph 73. And starting 5 lines down, principles, you cannot have a patent for doing something which a skilled person would regard as old or obvious but difficult or impossible to do. It remains equally difficult or impossible to do when you've read the patent. Put it another way, the perceived problem must be solved by the patent. And in light of my learned friend's submissions yesterday, it's common ground that the last sentence should be understood as the perceived problem must be plausibly solved by the patent. And that is consistent with the House of Lords decision in Connor. Now, the principle in Ausestec therefore provides an important constraint on what the patentee is entitled to rely upon for the purposes of non-obviousness. In short, if it was obvious to take a particular step leading to or towards the claimed invention, the patentee cannot be heard to say that the skilled person will be deterred from taking that step unless the deterrent is plausibly solved by the patent. So in Ausestec itself, the issue was whether it was obvious to take a particular piece of prior art called SHAD and to implement its teaching in the base station of the mobile network. And if your lordships will just turn back to paragraph 60, which is on page 307, one can see how the point was argued on appeal. The defendant characterising the judge's conclusion as including the finding that the skilled person would put off the obvious idea of moving the implementation of SHAD to the base station because of the implementation and performance issues found by the judge. And then if you go back to paragraph 73, just picking it up at the beginning of that paragraph, finally the defendants contend that the issues which the judge held would have deterred the skilled person from proceeding to implement SHAD at the base station remained issues for the implementation of the 525 patent. And if your lordships can then read on to the next paragraph of Lord Justice Floyd's judgment, paragraph 74, the judge rejects that contention and he says, on my reading of his judgment, the trial judge did not accept that the idea of implementing SHAD at the base station was on its face obvious. And then he says in the next sentence but one, the argument therefore doesn't get off the ground. Now the reason I direct your lordships to paragraph 74 of Ausestec is it shows that the Ausestec principle doesn't enter the analysis unless it is obvious to take the relevant step. So in Ausestec, the step was implementing SHAD in the base station. In the present case, the step is testing mirabegron in a rat to Truza assay with a reasonable expectation of success. That was the appellant's case below, and it remains their case before this court. Now, the judge found that that step was not obvious. And hence, my first submission to your lordships is to adopt Lord Justice Floyd's language. The Asustek argument doesn't get off the ground. My second submission is that the Asustek argument doesn't get off the ground for another reason. And can I ask your lordships and ladyship to take the grounds of appeal, which is core bundle tab 3, page 28. Paragraph 12. The claim in issue in these proceedings is to a remedy for the use of the treatment of OAB, comprising mirabegron. The claim requires mirabegron to be suitable for treating OAB, and the patent must show, as it has, that such use is plausible. Now that concession is rightly made for reasons which I will address your lordship and ladyship on in due course. But my submission is more fundamental than that. If the patent makes it plausible that mirabegron is suitable for treating OAB, then the arguments in relation to clinical uncertainties are entirely academic. Once they are stripped away, your lordships and ladyship are left with a conventional obviousness appeal. The judge has found that it wasn't obvious to test mirabegron in a rat detruser assay with a reasonable expectation of success, a conclusion that the judge was entitled to reach based on his findings of the common general knowledge, the teaching of 288, and his evaluation of the witnesses. In my respectful submission, a textbook multifactorial evaluation undertaken by a highly experienced patent judge. And my third submission is that insofar as the judge took clinical uncertainty surrounding beta-3 agonists into account, it was not, as the appellants contend, central to his assessment of non-obviousness. Rather, it was simply one of the reasons, and I emphasise one of the reasons, for the judge's finding that the appellant's obviousness case was deficient. With that introduction, can I indicate how I propose to structure my submissions? First, I want to respond to a submission that my learned friend made yesterday in answer to a question from Lord Justice Arnold. Second, look at 288, together with the judge's findings in relation to that document. Third, look at the judge's key findings in relation to the common general knowledge. Then go to the judge's assessment of the obviousness case. And finally, deal with a technical contribution.
Could I importunely ask you to turn the volume up just one notch?
In my voice?
Yes.
I'm sorry.
That's right. It's my difficulty.
I'll try to endeavour to do that. The question as to the lines on which my clients, Astellas, relied at the trial. Now, Dr. Turner identified two such lines. He said a general uncertainty that beta-3 agonist therapy would work for treating OAB pending clinical trials. Second, a question mark, he said, over the potency and selectivity of mirabegron. Now, I, speaking for myself, don't recognise either of those as having been put forward by Astellas to rebut obviousness. In other words, if, contrary to its primary case, it was obvious to take mirabegron forward into a rat detruser assay, the skilled person would nevertheless be deterred from taking that obvious step because of such concerns. And specifically, in relation to the first point identified by Dr. Turner, Astellas' case, and we'll see this in due course in the judgment, was that beta-3 agonism was one of a number of possible avenues for treating OAB that was under consideration at the priority date. It was no more, it was no less promising than any of the other avenues. And as we shall see, that is precisely what the judge found. The fact that there was no clinical evidence yet that beta-3 agonism would work to treat OAB was simply one factor going to the skilled person's confidence in the beta-3 agonist approach. Again, we're going to see that that is precisely what the judge found. And the fact that beta-3 agonists had failed in the obesity field dampened that confidence in beta-3 agonism as approach. Again, as the judge found. Certainly not advanced as lions in the path, merely the flip side of the appellant's case. And if your lordships take the judgment, I just want to pick it up in 3 paragraphs. The first of those is in paragraph 30. And the judge is here dealing with a point that is ultimately of no consequence. But picking up at 4 lines down, I accept the principle, which I don't think counsel for the claimants really disputed, that its relevance to the present case is low, because if the main planks of the claimant's case were made good, that selected beta-3 AR agonists were understood to have excellent prospects to treat OAB. So one of the main planks of the claimant's case was to rely upon the prospects in relation to beta-3 agonism. Can I then pick it up at 144? Sorry, that's not the right reference. It's, sorry, 114 rather. So page 131. The judge refers to Dr. Argentieri's evidence introducing 6 particular avenues, and you can see those just on the previous page, 113 little 2, antimuscarinics, beta-3 agonists, potassium channels, and 3 others. His evidence was that the first 3, so that includes beta-3 agonism, was the subject of a lot of interest or recent work in 2002. And then the last reference to take your lordship and ladyship to is paragraph 144. 201, sorry. 201. And we'll look at this in due course, but we'll see the judge referring to the claimants, so the appellants, trying to bring some unity and reality to their arguments about agonism on the one hand and 288 on the other, by contention that the mechanism had been seen as extremely attractive for some time. So that is the way in which the case was articulated by the appellants, and what I've identified to your lordships as the 3 propositions as going to general uncertainty was my case, that agonism was simply one of a number of avenues and didn't stand out above or below any of the others. Now, as regards Dr. Turner's second point, which is a question mark over the potency and selectivity of mirabegron, I have no idea where Astellas' purported reliance on potency comes from. As for selectivity, can I ask your lordships to take paragraph 35 of the judgment. This is in the context of the judge's discussion of azostat. He identifies the risks of side effects a main potential cause of side effects for beta-3 agonist under consideration would be off-target effects if the compound turned out to be an agonist beta-1 or beta-2, as well as the skill team might be deterred from proceeding with a compound whose selectivity was unknown. But since the patent contains nothing to say whether or to what extent mirabegron was selective for beta-3 over beta-1 and beta-2, Astellas cannot rely on this, as its counsel accepted. So selectivity was most definitely not, contrary to what my learned friend said to you yesterday, advanced as a lie. Can I then turn to 288, prior art? Now, the starting point in relation to 288 is the judgment, paragraph 142 to 169, where the judge provides a detailed account of what the document discloses and how it will be understood. Now, those paragraphs in my submission are not only the starting point, they're also the end point, because there's no appeal against any of the judge's analysis or any of his findings in relation to 288 therein. On the contrary, the appellants submit, and I quote from paragraph 10 of their skeleton, the prior art 288 is correctly analysed by the learned judge at 142 to 169 of the judgment. Now, there are a number of key points in my submission that emerge from the judgment, and could I just identify those, please? The first we can see in paragraph 142 of the judgment. The judge refers to the abstract, referring to an amide derivative according to a Marcouche formula there set out. And could I ask your lordships just to look at that? It's in the supplemental bundle. Tab 2, bundle reference, page 19. My Lord Justice Arnold will be familiar with a Marcouche formula. I'm sure your Lordship and Ladyship will gather that it's a structure with various possibilities and defines a list of legitimate or permitted substituents at various positions.
Yeah, it's a formula for defining a class of chemical compounds.
Correct. So that's the Marcouche. The second point to take your lordships to is what the authors themselves say about the role of beta-3 receptor stimulation in insulin secretion and insulin sensitivity. So pick that up, please, at page 35 of the bundle. And in the second paragraph, under industrial applicability, the author says, confirmed by glucose tolerance test, hyperglycemic test, and insulin resisting model animals, as described later, compound of present invention has good insulin secretion promotion and good insulin sensitivity potentiating action, so its usefulness in diabetes mellitus is greatly expected. And then this sentence, although the beta-3 receptor stimulating action may have a possibility of participating in expression of the insulin secretion promoting action and the insulin sensitivity potentiating action, other mechanisms might also possibly participate therein, and the details thereof have been still unknown yet. And if I could take your lordships to what the judge said about this, because he received submissions on the significance of that teaching. So it's at 148. And could I just ask your lordships to read for yourselves paragraph 148? The fourth point is the absence of any biological data of any relevance to OAB, nor any experimental data concerning the affinity or the potency of any of the compounds. If you take the judgment, that is paragraph 168. And your lordships will see in 168, having discussed questions of selectivity, the judge says the argument over which compounds were tested for selectivity rather overshadowed a related point, which I think is of importance, which is that on any view, there is no data about the affinity or potency of any of the compounds, and no efficacy test of any relevance to OAB. And whilst we have that page open, could I just ask your lordships to read to yourselves paragraph 169? The fifth point concerns statements made by the authors in relation to compounds tested in the beta-3 selectivity test. So picking it up back in the 288 bundle at page 40, going over to page 41. So at the bottom of page 40, internal 20, 3 lines up, amount of production of cyclic AMP in each cell was measured by an RIA method using iodinated cyclic AMP. Intensity of action of each compound was compared by calculating the BD2 and the maximum activity. And then the next paragraph, it has been ascertained that the compound of the present invention has a selective stimulating action to human beta-3 receptor. If I could ask your lordships to take paragraph 159 of the judgment.
149.
159.
I'm sorry.
And those are the two passages that the judge is referring to in that paragraph. He quotes them. He says there's no numerical data. And he says this is the result that Dr. Argentieri called compelling, which in my view, given the context, can be seen to be a significant overstatement. And just pausing there, that was one of the reasons. Sorry.
I could. No, that wasn't the...
That wasn't bending...
That wasn't a Djokovic, that was a...
That was one of the reasons given by the judge for preferring the evidence of Astellas' experts over Dr. Argentieri. And can I just pick up on that and turn back to paragraph 21 of the judgment? You'll see in paragraph 21 criticisms which were levelled at Dr. Argentieri on behalf of Astellas. 21 little 4, that he said 288 contained data, when in fact it did not in the relevant respects. And the judge addresses that in paragraph 24. Which is the Dr. Argentieri's evidence in relation to 288, this particular point. And then you see in paragraph 25, overall these points, so that's one of a number of points, and I'll leave it to your lordships to review paragraphs 21 and 24. Overall, these points left me with the impression that Dr. Argentieri was trying a little too hard to find points in favour of the claimants, not enough to lead me to reject his evidence outright. Many of his points were well made and solidly supported, but I bear it in mind, and I thought that Astellas' witnesses were overall more fair and balanced when it came to the issues on CGK and obviousness, and put themselves in the position of the ordinary, uninventive addressees better than him. So returning to my list of points on 288, the judge in paragraph 162 and 163 addresses the structural diversity, if I can put it that way, of the compounds, the exemplified compounds, of which there were 6. And in 163 he says some of the 6 compounds were structurally similar to each other and some were not. Dr. Argentieri accepted that examples 1, 4 and 6 were similar to one another, whilst 2, 3 and 5 stood out as different. And he accepted that even for the relatively similar ones, it was not possible to infer from their structure that they would have the same activity. Just going back to 288, could your lordships then go to paragraph, bundle page 38, internal 18. This comes just before the testing methodology, and there's a reference there to the action of the compound of the present invention has been ascertained. And there are references throughout the document to the compound of the invention. Dr. Turner characterised it as a possible translation thing yesterday, but on which he said nothing really turns. That certainly wasn't the judge's view, as one sees in paragraph 152 to 154 of the judgment. I ask your lordship to read that. And in particular, the very last sentence on 154 cannot very well mean any compound of the invention, since clearly not all within the Marcouche group could have been tested.
That's the oddity of it, because at first blush, you would assume that that was exactly what they meant. And at first blush, you would assume that when they say the compound of the present invention, it must mean the compound as defined in the abstract, i.e. the Marcouche.
That's right.
But then a moment's thoughts tells you that can't be right. So you're then left with the quandary of what on earth do they do?
If it was a Marcouche with 2 or 3 members, then things might be different.
Yeah, but this has got what, thousands?
Well, no one advances any numbers. I'll tell you why, because one of the substituents actually isn't properly defined. Those for which there are examples, I've done the maths, it's many, many thousands.
Yeah.
And then the 7th point, one can see straight from the judgment, paragraph 162, starting at 164, which compounds are disclosed as having been tested and for what. You'll see the rival submissions in paragraph 164, and then the judge's findings in 167. And his overall conclusion, for the reasons that he articulates in the beginning of that paragraph, is that the skilled addressee would think that no safe conclusion could be reached over what testing had been done, other than the one data point in example 6. They, the skilled addressee, would have the hope that if they tested the 6 compounds, the 6 exemplified compounds, they might get some positive results, but no expectation for any particular compound, which obviously includes merobeglon.
And forgive me, but your submission is that unless the appellant can demolish that assessment, you win. Or is that too simple?
The starting point is it's not challenged.
Exactly.
Well, exactly, but
I could just stop there. It's
expect
not
you.
challenged. But if the question is reasonable expectation of success, I take 167.
thank you.
can I now turn to the appellant's submissions on what 288 discloses in relation to 288? And my learned friend submitted yesterday that the patentee had taken a known human selective beta-3 agonist. Now, by known, he means known from 288. Now, that submission, in my respectful submission, is plainly unsustainable in the light of the judge's finding that we've just looked at in 167. Now, the other way he's put it, both in writing and orally, is that mirabegron is disclosed as a human selective beta-3 agonist. I agree that the compounds defined by the Marcouche, all of them, are put forward as human beta-3 selective agonists. But on the judge's findings, the skilled person would have no expectation that mirabegron would be a beta-3 selective agonist. So it's disclosed, mirabegron, as a human selective beta-3 agonist, but 288 does not disclose, nor would be understood to disclose, that mirabegron is in fact a human selective beta-3 compound. And then finally, my learned friend submitted yesterday that the judge didn't suggest that 288's teaching, that is to say that mirabegron is a selective human beta-3 agonist, would be rejected by the judge. The judge didn't make that finding. The simple answer is that 288 contains no such teaching, for exactly the reasons that we've just been looking at, paragraph 167 of the judgment. Hope that if they tested, they might get some positive results, but no expectation for any particular compound. So that is 288. Can I then turn to the common general knowledge? And there are four topics that I wish to address you on. The first of those is clinical trials. And can we start in the judgment by going to paragraph 96? And the judge there records that one of the claimant's points, beginning of 96, was that the idea of using beta-3 agonists for treating OAB had momentum. And the judge agrees with this. And he agrees with it for two reasons. Significant results advancing the understanding of the role of beta-3 agonists in the bladder had been achieved in a period of just a few years leading up to the priority date. And suggestions for therapeutic potential had been made swiftly thereafter. And he then says, I'll need to take account of this when considering beta-3 agonism in the context of the other mechanisms under consideration. And as we'll see, that is precisely what the judge does later on in the judgment. Now, then going to paragraph 97, he says the claimants, so the appellants, also rely on the suggestions in the articles mentioned above about future use of beta-3 agonists in human clinical trials. And the judge explains that there are two ways of reading those statements. First, the lack of clinical trials was a gap in the art's knowledge and therefore a limitation, or an indication that the in vitro and in vivo data were so promising that clinical trials were warranted in short order. And that latter formulation reflected the appellant's case. To quote from their closing submissions, they said the art had reached the stage where human selective beta-3 agonists were to be taken into clinical trials to validate, and I emphasize validate, further their potential. Validate as in confirm, corroborate. We'll see how the judge resolved those two possible interpretations in a moment. In paragraph 98, he makes a finding that the skilled person wouldn't be aware of any clinical trials. Paragraph 99, the judge is here addressing the fact that beta-3 agonists were known to have failed in the clinic as anti-obesity agents, despite having worked in animals. And he finds that one possible reason is the one given in Yamaguchi, that they were weak, partial agonists of the human receptor and non-selective. But more generally, he says, the reasons, or finds more generally, the reasons were not fully understood. Now, what's the significance of that? Precisely, as the judge says in the first sentence of 99, that the increasing understanding of beta-3 agonists in the bladder, identified in paragraph 96 as one of the reasons for the momentum, would be tempered by the failed obesity trials. And then moving on in paragraph 100, the judge comes back to resolve the issue posed in 97, and he finds that the lack of clinical trials was a gap in the knowledge. They would probably come soon, but their outcome was fairly uncertain. So in so finding, what the judge has done is to reject the alternative formulation that the in vitro and in vivo data were so promising that the clinical trials were warranted in short order. The second point that I would like to address your lordships on, and ladyship, is the any beta-3 agonist point. So this is paragraph 101. The judge finds that it was not common general knowledge that any beta-3 agonist would work to relax detrusor, and he gives his reasons in paragraph 101. He refers to the cross-examination of Dr. Murray, who had disagreed. He explains that Dr. Murray supported his evidence with his experience at Pfizer. He refers to Dr. Murray's evidence that predictability for agonists was always difficult and more complex than for antagonists. And he says at the end of that paragraph, Dr. McMurray's experience was obviously not common general knowledge, but it lends reality and support to his evidence. Now, I'd like to show you, lordships, you've seen a bit of it already, the particular cross-examination that the judge had in mind when he was
All right, but before we look at the cross-examination, what do you say to the point that this is post-priority date work?
I accept that there is one answer that the witness gives in relation to post-priority. But when we look at the cross-examination, we will see that Mr. Turner took the witness out of his post-priority experience, back to 2002, the common general knowledge, and asked the question devoid of his experience at Pfizer. So I'll just show you precisely why I say that. So it's tab 9 of the supplementary bundle. Bundle reference page 147, internal 374. And before we just look at this series of questions and answers, may I ask your lordships just to bear in mind what Dr. Turner said yesterday, that it was never his position that any beta-3 agonist would be expected to relax detrusor tissue. Rather, his case was directed at human selective beta-3 agonists. Bear that in mind when we look at these questions. So the first question starts, that I want to pick up on, is 374, line 18. And this is Dr. Turner's first attempt at establishing that beta-3 agonists, not, it would appear, human selective beta-3 agonists, would be expected to relax rat detrusor. And the answer he gets, one sees it at line 22 of 374, is based on Dr. McMurray's experience at Pfizer, which postdates. So turning over the page to 375, Dr. Turner takes Dr. Murray back to the common general knowledge in 2002 he says, obviously that all came later. He says, certainly the common general knowledge of the skilled person looking at Yamaguchi, if you got a beta-3 agonist, not a human selective beta-3 agonist, a beta-3 agonist, you would expect it to have an impact on a rat-to-truth assay. And the answer he gets back is, I think it was common general knowledge would be that a pharmacologist who worked in GPCRs and understood agonism, you would say that if you got a good, potent, good affinity compound, it's likely that you would see that in effect. So if you saw potency and good affinity, then you would be likely to see that effect. It's not an acceptance at all that any beta agonist would be expected to have an impact on rat detrusor. And then my learned friend tries it another way. He says, it sounds to me like you were a bit surprised when you went to Pfizer and were seeing compounds that did not work. And the answer he gets back is no. And what the witness explains is the point about complexity, working with agonists compared with antagonists, particularly in the context of G protein coupled receptors. And it is the second and the third answers on which the judge placed particular lines, and one can see that in paragraphs 182 and 183 of the judgment. Sorry, 181 and 183. The judge is recording that second answer about good, potent, good affinity compounds. And in 183, he's referring to that third answer. And in 184, he says, so he gave further reasons to explain why it was too simplistic to assume that any beta-3 agonist would work. So my submissions in relation to the judge's finding in that paragraph, in the light of that evidence, is the judge was plainly entitled to make that finding. Yes, the judge had referred in the course of that exchange to his post-priority experience, but the judge simply relied upon that evidence as lending credibility and support to his primary evidence. His primary evidence being given in that second and third answer. Now, that's my primary submission. And can I then address you on the particular paragraphs of the transcript which my learned friend relied upon yesterday in order to rebut that evidence? So I'm staying with Dr. McMurray. And I turn to bundle page 152, internal page 391, line 25, and the question is, I understand, if something is presented to you as a beta-3 agonist, and someone says, look, I've tested it, and it is a beta-3 agonist, and just bear in mind here that we're just talking about beta-3 agonists, no suggestion of human selective. You'll be interested, because you don't have one, let's assume you do not have one already that you're working on. You'd want to recreate that beta-3 selective in your own hands. You want to test it in a rat detrusor muscle, or in a human detrusor muscle, would you not? And the witness says yes, that would certainly be the route that you would take. But of course that's predicated upon, unlike 288, that the compound has been tested and been shown to be a beta-3 agonist. So we're a world away from 288. My learned friend also took you to some cross-examination of Dr. Mills, which is in the preceding tab. So tab 8. And the first passage that you relied upon is at page 116, internal page 252. And it's the cross-examination or the question that starts at line 15 and runs to 21. Would the skilled person, the skilled team in November 2002, have been aware of any beta-3 agonists, again, any beta-3 agonist, not human selected, which did not cause bladder relaxation in the in vitro tests that have been described and discussed in vitro bladder strip assays? I don't believe they would be aware of any that did not cause it, because I think the Yamaguchi article represents essentially what they would have understood. Now, the appellants have reproduced that question and answer in paragraph 54 of their skeleton, where they submit that, and I quote, the only properly available interpretation of that cross-examination is that it was common general knowledge that beta-3 agonists relax rat detrusor muscle. In my submission, the witness is saying no more than from what I, as a clinician, know about beta-3 agonists. They have the capacity to relax detrusor. He's not saying that the clinician, and indeed he wasn't asked, he's not saying that the clinician would therefore assume that any beta-3 agonist would have had that effect. And moreover, the clinician is not working in a vacuum. The clinician is working alongside a pharmacologist whose views on the matter are as described by Dr. McMurray. And just to further, if I may, the point that I mentioned just a moment ago, that the appellant's case is said never to have been that just plain beta agonists were expected to be effective in detrusor assays. My learned friend says his case was always about human selective. Let's just turn on to two other paragraphs, or two other passages in Dr. Mill's cross-examination. The first is page 121, internal page 272. Paragraph 12. All the papers we are looking at are referring to beta adrenoreceptors in generality. The skilled person would understand there's an expectation that any beta-3 adrenoceptor, any full beta-3 adrenoceptor agonist, or even a partial one, will cause relaxation of the detrusor muscle in vitro in the bladder strip assay. This is the understanding, is it not? So that's, again, it's just put at the level of generality of a beta-3 agonist. And you'll see the answer that the witness gives there. I think yes, but there's a body of evidence that you've taken me to which I do not think would have been within the skilled clinician understanding or knowledge at the time. But there seems to be some evidence suggesting that more than one beta-3 agonist can be shown to have an effect. And then the last passage, just to take your lordships and ladyship to, is page 132, which is internal 316. Picking it up at line 6, I put it to you again. I do not think we've seen a single beta-3 agonist, whether it's partial, whether it's full, whether it's selective, or whether it's non-selective. There is not a single beta-3 agonist in the papers that does not produce a result on the rat bladder assay. Yes, in the published data, there is not. So certainly the way in which the case was put to Astellas' witnesses, it was put on the basis of a generality as to beta-3 agonists, was certainly not put on the basis of human selective beta-3. And indeed, it hasn't, until my learned friend stood up today, been articulated that that indeed was the case that was run below. If you take the core bundle, and I'm looking at my learned friend's skeleton argument on the appeal. So it's core bundle tab 7, page 57, first of all. paragraph 2, there is no dispute that at the priority date it was known that beta-3 agonists had potential to treat OAB in humans, but in the absence of clinical data, trials data, and so on. So that's put at the high level. And then secondly, internal page 70, paragraph 39, there was no dispute among the experts that human beta-3 agonists had potential for use in therapy. So again, beta-3 agonists in general. And then turn down to paragraph 40. In cross-examination, Dr. Mills accepted this was generally known even before reading the priority document. And look at the question. Even before you read the priority document, you have expected a beta-3 agonist, not a human selective, a beta-3 agonist to be effective to treat overactive bladder. So it's for those reasons, my lord, that I don't accept for a moment that the appellant's case at trial was only ever about human selective beta-3 agonists. Furthermore, there is a real oddity about that case. There was only one known, as a matter of common general knowledge, human selective beta-3 agonist, and that's the L507 compound referred to in Yamaguchi. In which case, how could it be said that human selective beta-3 agonists as a class would be expected to relax a detrusor muscle? So that is my second topic under the common general knowledge. My third is quite a short one, and it arises from the judge's finding in paragraph 107. And the reason for identifying it now is that we'll see in due course that the judge refers back to 107 in part of his assessment. So could I ask your lordships and ladyship just to read paragraph 107? And my fourth and final topic, as far as the common general knowledge, is the therapeutic approaches. And if I could ask you to take the supplemental bundle. And before we just look at the document, I wish to show you, lordships and ladyship, there was a significant dispute at trial regarding the common general knowledge in relation to other therapeutic approaches. And one can see that at tab 10, the supplemental bundle. This is the statement of agreed common general knowledge and list of points in dispute. And if you turn to paragraph 177, right at the bottom, common general knowledge and dispute, the following table represents the common general knowledge and dispute between the parties. And looking at that table, you'll see in paragraph 3 what therapeutic approaches were being investigated or had been postulated in the literature by 2002, and, if relevant, the extent of the common general knowledge in relation thereto, including, in particular, those target mechanisms referred to in 2.2 and 2.56 of the Astellas schedule. Let me just show you that. It's behind tab 5, page 84. And in the 2 pages, between paragraphs 2.23 and 2.25, are identified, I think the judge said, in around 20 different approaches, therapeutic approaches. So that's what the third topic in that schedule is alluding to. And then going back to the schedule. Item 6 is how the common general knowledge regarding the role of the beta-3 adrenoceptor in detrusor function would be understood in the relevant context, including how speculative or promising that information was, and if relevant, including in comparison with the other possible therapeutic approaches under consideration at the priority date. So those are the two issues. Other approaches and how speculative or promising was beta-3 agonism compared with them, which the judge resolves, first of all, in paragraph 113 to 117. So in 113, he says there were several streams of evidence about the various possible mechanisms for investigation, and in particular, he refers to the schedule, the technical background that I've just shown you, paragraphs 2.22, listing therapeutic avenues under investigation by way of 3 categories, and he says at the end of ABC, and in total there were about 20 options listed. Judge then refers to Dr. Argentieri's slightly more limited approaches. We looked at 114 before, but just go to 117 for current purposes. He says, overall, therefore, I prefer the evidence of Astellas' witnesses as to the range of possibilities which was wide. So that's a number of possibilities. In terms of how speculative or promising they were ranked, the judgment on this topic starts at 118 and runs to 125. But for my purposes, if your lordships and ladyship just read 125, that's the ultimate finding that the judge makes. This was a field where there was known to be a real problem with the existing treatment, in which there were a significant number of possibilities to be considered, none of which was the clear favourite, and none of which had an overwhelming clear rationale or body of evidence. The lack of a clear direction forward was in a way evidenced by, and so on and so forth. So significant number of possibilities, none had an overwhelming clear rationale or body of evidence, and there was no clear direction. So that completes my review of the key propositions in the common general knowledge. Can I now turn to the judge's assessment of the obviousness case? And I'd like to start, if I may, at paragraph 174. The judge articulates the nature of the claimant's case, and in 175 he says, this is my paraphrase, and he then reproduces the appellant's case as summarised in opening. And as we shall see, it was that formulation, as set out in 175, which the judge returns to in his overall assessment. Then in 176, the judge observes that the claimant's case is a little unusual in that the common general knowledge does nearly all the heavy lifting and provides all the rationale and motivation. The function of the cited prior art is simply to provide the identification of mirabegron to be plugged into an argument which could apply to any selective beta-3 agonist. And, of course, rationale and motivation front and centre in almost every case where a patent is challenged for obviousness. In this case, what is the rationale? What is the motivation that leads the skilled person to see in 288 a potential new or improved pharmacological treatment for OAB? And as the judge says, on the appellant's case, it all comes from the common general knowledge. Now, he then sets out Astellas' key responses on that. And the first 3, 1, 2, 3 in paragraph 177, are directed at the common general knowledge. And if I can summarise the effect of 1, 2, and 3, is that there was nothing in the common general knowledge that elevated beta-3 agonism above any of the other therapeutic approaches. We can then turn on to paragraph 192. This is under the heading assessment. The judge says he has come to the conclusion that the obviousness attack over 288 fails. He says, I'll explain my reasons without, I hope, unduly repeating what I've said already. A clear marker that his reasoning, which we're going to see in a moment, is based, at least in part, on his earlier findings. 193, the judge accepts that the beta-3 agonism as a mechanism had momentum relevant to OAB, arising from recent advancement in the understanding that he identified in relation to common general knowledge. And hence beta-3 agonists had, in a general sense, potential agents. They were potential agents to treat OAB. So the judge is here accepting the first proposition in the appellant's case, that beta-3 agonists have the potential to treat OAB, subject to the qualification in a general sense. And that qualification is then articulated in paragraph 194, where the judge identifies two defects in the appellant's case, and he says that both can be seen clearly in the formulation of the case that the appellant put forward in opening. So it overstates the confidence that I'm looking at 194, by that the judge means the momentum arising from recent advances in the understanding, overstates the confidence that that would give the skilled addressee, and it oversimplifies the situation, in particular to the effect that any beta-3 agonist would be likely to succeed in treatment. And then turning over the page, the judge sets out his reasoning, 195 to 198, where he addresses the overstated confidence. And let's just take them one at a time. The first 195 is the failure of beta-3 agonism as a mechanism for treating diabetes. And as we saw earlier, the judge found in paragraph 99 that whilst the increased understanding of beta-3 agonists in the bladder provided momentum for their use in OAB, this was tempered by the failure of the beta-3 agonists in that context. 196, the clinical prospects. The judge is here referring back to his finding in paragraph 100 that the lack of clinical trials was a recognised gap in the knowledge of the art. It probably comes soon, but their outcome was fairly uncertain. 197, large number of possible therapeutic approaches in play, referring back to his finding in paragraph 117. And 198...
Sorry, referring back to paragraph
117.
117, thank you.
And then 198 is the conclusion. So I thought that Dr. Mills and Dr. Murray gave a much fairer impression of the state of play in seeking to improve OAB treatments than did Dr. Argentieri. Possible that beta-3 agonists would work for OAB, it's possible they wouldn't. Same could be said for a number of other mechanisms under consideration for OAB that I've touched on above. Now just pausing there, if we go back to page 141 of the judgment. Sorry? We looked at paragraph 176 and 177. And in 177, those three reasons which the judge identified as Astellas' key responses are the three reasons which the judge identified as the basis for his finding in paragraph 198, his overall conclusion, that the claimants had overstated the confidence with which the skilled team would proceed in the context of beta-3 agonists. So in my submission, two submissions, one can see that those three propositions in 177, 1, 2 and 3 not relied upon by Astellas as lions in the path, and nor did the judge. In my submission, what the judge is doing in paragraphs 195 and 198 is simply impugning the appellant's case, appellant's case as to the rationale and motivation by reference to and accepting what Astellas contended was the true position. Turning on from 198, 199 is the oversimplification. The oversimplification to the effect that any beta-3 agonist would be likely to succeed as a treatment. And in 199, in the middle of the paragraph, the judge says, my findings on the evidence as set out above are that this is not so. That's a reference to his finding in paragraph 101, which we looked at earlier. And then he goes on to say, it could not be assumed that any beta-3 agonist would work. And the appellants say that the judge meant work in the clinic. In my submission, that's not correct. The cross-examination of Dr. Murray, which we looked at, and which gave rise to the judge's finding in 101, was all about the impact on isolated detrusor. Furthermore, if you read on, the judge refers to the cross-examination of Dr. Mills. We looked at that earlier. For the note, it's tab 8, internal transcript reference 316, line 6 to 12. Dr. Turner was asking specifically about activity in rat detrusor. And then finally, the judge refers in the last sentence of that paragraph to Dr. Murray's experience at Pfizer, which, as I've said, was in vitro, not in the clinic. What the judge then does between 200 and 203 is he goes on to consider 288. First sentence of 200, he says, this does not mean that the skilled addressee would positively think that mirabegron or the other examples in 288 would not work. And in my submission, the judge is using work in precisely the same sense that he's used it in the immediately preceding paragraph. He goes on to explain in 200 that 288 doesn't show it's working, choice of compounds and structures to explore and test. 201, he says the claimants tried to bring some unity and reality to their arguments about beta-3 agonism on the one hand and 288 on the other, by the contention that the mechanism had been seen as extremely attractive for some time by the priority date. It was held up by the lack of appropriate compounds. Then it was said 288 would provide a good way forward for the first time. So the judge says, I've rejected this on the facts in dealing with common general knowledge. And that is the judge referring back to paragraph 107 in the common general knowledge section. And he goes on to say, the skilled addressee would not think that there was a limitation such they would naturally decide to proceed with the ill-characterised compounds in 288. And the judge has got there firmly in mind the inadequacies of the disclosure of 288 for the reasons that he's identified in his analysis of the document. Paragraph 202, the judge says it's of some relevance that 288 doesn't mention OAB, but not critical in isolation. Then a discussion about the a question which he had posed to counsel for Astellas. And then towards the end of that paragraph, 4 lines up, he says, I certainly do not think that counsel for Astellas was abandoning all its points about the general uncertainty around beta-3 agonism and OAB. General uncertainties in my submission in the sense that it was possible that beta-3 agonists would work for OAB and possible that they would not, just like the other potential avenues as the judge had found in paragraph 198. And then the last sentence of 202, just the last few words of 202, he says, in my view, the shortcomings of 288 and the art's perception of beta-3 agonism has to be seen and assessed as a whole. So again, another reference to the inadequacies of 288. And then finally, 203, the judge accepts that making 6 compounds wouldn't be burdensome, but he says a small part of the picture. And one still has to inquire which compounds, which of the 6 compounds, or if it was more, 23 to make, for what purpose, and with what confidence that they might succeed. So, my Lord, the judge has undertaken an entirely proper, multifactorial evaluation of the appellant's case. And he's rejected it. And importantly, the judge did not find that 288 made it obvious to test mirabegron in a rat detruser assay. That is why I say that the Auserstake appeal doesn't get off the ground. In any event, the judge was plainly entitled to find that it was not obvious to test mirabegron in a rat detruser assay with a reasonable expectation of success, not least based upon his analysis of 288. And therefore, clinical issues are entirely academic in light of the concession that the patent makes it plausible that mirabegron is suitable for OAB. And in any event, insofar as the judge took account of clinical outcomes, he did so as a reason for rejecting the appellant's obviousness case. Not a line in the path that had been put up by Astellas, a deficiency in the obviousness case that had been put to him by the appellants. Can I then turn to the technical contribution, which is one of the points my learned friend made today. And we can start the analysis at paragraph 102 of the judgment. And this is the section of the judgment where the judge is addressing the common general knowledge. And he says, Yamaguchi identifies the need to find better beta-3 agonists. What it says about them has an emphasis on selectivity, and the one is used L507 was selected, although no information is given about potency, but clearly also refers to the need for agonists to be full and potent. And just pausing there, fullness is a reference to whether one is looking at a partial or a complete agonist. Potency is a reference to the concentration of the compound required to achieve a given effect. And as the judge finds and accepts, Dr. McMurray's explanation was that the problem would have been seen that the compounds tried had been weak, in other words, not very potent, more than they had been partial agonists. And that was the context for a further debate about the common general knowledge situation in relation to the existence of good human beta-3 agonist compounds. If we then turn on to the judgment at paragraph 131. Well, let's pick it up at 126. This is the judge's commentary on the teaching of the patent. And 131, he's looking here at example 1. Example 1 is done in an in vitro model using strips of rat detruser, which are made to contract by the application of carbachol and potassium chloride. The relaxant effect of mirabegron is assessed and compared with that of GCP177A. This is the important bit. Mirabegron is seen to achieve a much greater relaxation and at lower concentrations than 177A. He says this is expressed in a variety of ways, but the details do not matter. Well, we did look briefly at the patent. Could we just take it out again for a second time? So it's in the supplementary table. Tab 1. Bundle reference 4, internal 3. paragraph 5 identifies 177A as a known selective drug. The experimental details and the results are presented on pages 9 and 10, but it may be easier just to see them figuratively, which one can pick up at bundle page 14, figures 1 and 2.
The reference to selective was in paragraph 5.
In paragraph 5.
Yeah. Last line.
Yeah, sorry, I'm just checking. Yes, that's right. The penultimate.
Yeah.
Penultimate line of paragraph 5. So just looking at those two figures on page 14. The figure 1 is a contraction by exposure to carbachol. Now, carbachol is a muscarinic agonist. Hence, this assay is looking at a compound's capacity to counter an agonist of the natural contractile pathway. So the x-axis relaxation from 0 to 100%, 100% being that achieved by a compound called pavavarine, and that was a well-known smooth muscle relaxant, and the evidence was that pavavarine would be expected to affect the maximum degree of relaxation. And one can see that GCP177A only achieves, and I'll give you the number, it's set out in the table, 15.7% relaxation, even at the maximum concentration of 10 to the minus 4 molar, whereas mirabegron gets down to 94% relaxation at that same concentration. But if you take the maximum relaxation that's achieved by 177A, in other words 15.7%, mirabegron achieves that at a much lower concentration. A concentration not of 10 to the minus 4 molar, but around 3 times 10 to the minus 7 molar. And it's on that basis that the authors of this document identify mirabegron as being 270 times, just make sure I get the actual word that they use, having an action strength that is 270 times that of 177A, 177A being a selective beta-3 agonist. And then a similar exercise is undertaken in figure 2. This is a different contractant, potassium chloride, and that causes the release of stored calcium, not part of the normal in vivo pathway for contraction, but nevertheless informative. And when I say informative, can your lordship and lordships and lady turn on in the same bundle to tab 3? And page 54 of the bundle. This was Dr. McMurray in chief, paragraph 711. And could I ask your lordships to read 711 and then over to 712? Sorry, there's quite a bit to read through.
on 54.
Yep, 711 on 54 over to 712 on 55.
Thank you.
And one more paragraph before we get to plausibility, which is 7.16 on page 57. None of this evidence was challenged. 7.16 on page 57. And then finally, the witness moves on to plausibility. This is page 63. Now he's actually doing plausibility in the context of priority, which was an issue at an earlier stage, but that doesn't matter for current purposes. It's paragraph 9.6. Where Dr. McMurray is looking at example 1. The information provided by example 1 is not definitive evidence that mirabegron would relax human detrusor smooth muscle either in vitro or in vivo. However, the example would provide the skilled pharmacologist with reasonable scientific grounds to suppose that mirabegron would act as an agonist on the human beta-3 adrenoreceptors in the human detrusor and therefore have a strong relaxant effect on the human bladder, consequently reducing the associated symptoms of urinary incontinence, urinary frequency, and urinary urgency. And that is why I said to your lordships and ladyship when I opened my submissions that the appellants had rightly now accepted that the data in the patent make the claimed therapeutic effect plausible. Now, how does that then feed on to the technical contribution? Technical contribution of this specification is that it discloses for the first time that mirabegron is a strong and potent beta-3 agonist in rat detrusor. It is that disclosure which makes plausible the claimed therapeutic effect. And the clinical use is therefore part of the technical contribution because it's made plausible. How does that compare with 288? 288 discloses mirabegron as a chemical entity. It even goes so far to tell the addressee how to make mirabegron. But there are no biological data that relate to mirabegron at all. And the indications which are provided in terms of therapy in 288, well, they are a laundry list. They're principally diabetes, a whole host of others, but no mention of OAB. So there's a compound whose activity, whose biological activity, is unknown. That's the comparison that is relevant for the purposes of the technical contribution. My Lord and Lady, those are my submissions. I'm not going to move my respondent's notice, so that need not trouble your lordships and ladyship.
Thank you very much. Any reply?
Yes. My Lord, there was a suggestion at a number of points that counsel below should me put the case differently to the witnesses. We'll just deal with that first. Of course, lots of topics were explored with the witnesses at different stages. The fact is the case that was put at trial is the same as the case being put before you today, and I think rather than hand up our entire closing, I think one can get that out of 174 and indeed 175 of the judge's discussion of what our case was, 174, 175, I don't see anything inconsistent with that. That's 174, 175 is the judgment. That's not to say that other matters weren't explored with witnesses, including the fact that it was obvious to take a beta-3 agonist and put it into a rat bladder assay, and that was certainly cross-examined to. We submit nothing wrong with that, and indeed it is a relevant factor. But really, the difference between my learned friend and myself is this. It's the nature of a relevant technical contribution. And I come back to the example that I use with Dr. Barron as illustrative of the problem. If ASUS tech does not apply in these circumstances, then in any case, potentially you could have a patentee come along and patent a putative drug with a known mechanism of action and say, well, it's uncertain, people wouldn't take it forward because it's uncertain as to whether or not it'll work in the clinic, and rely on that. And then they could the following day file the same patent, and that would turn the patent system on its head in our submission. Another way of looking at it is, what is the technical contribution of the patentee which is going to justify a 20-year monopoly, in this case, with the increased prices the NHS are going to have to pay, and others, if generics are prevented from getting on the market? What is it that they have done? All they have done is point to 288 and taken one of 6 examples and said, look, that could be used for OAB when it's already been disclosed as a beta-3 selective agonist. So they've contributed nothing. They're not the first people to say that it's a beta-3 human beta-3 selective agonist. They're not the first people to suggest that selective beta-3 agonists can be used to treat OAB. And they provide nothing new in terms of data to give any confidence in relation to that subject to the
Do you accept that the references that we were taken to about 5 minutes ago in tab 3, paragraphs 711, 716 and 96 are what justify the assertion of plausibility?
No, we absolutely don't. Oh, no. Well, plausibility, our case, if you ask about our case was that it is plausible that beta-3 agonists can be used for treating OAB. That's what Yamaguchi says. And plausibility is a very low threshold. If that wasn't already in the art, no, those assays wouldn't of themselves be sufficient. And I'm going to come on to that to explain why in a moment. So we don't accept that. So the technical contribution, perhaps now is a good time to go to that. So look at tab, somebody could remind me where it is. It's tab 3, isn't it? 712. 712. 73. We went to 712. I think my learning friend started a little earlier. So there are 2 things to keep in mind with this assay. First of all, this is an absolutely standard assay. There's nothing inventive taking a known compound and putting it in this assay. It's in Yamaguchi. Everyone was doing it. That's the way you do it.
Yeah, and Dr. McMurray says that at 7.40.
It says that at 7.40. So well, a point was made on 712, and it's that, look, you've done it with, you looked at 2 mechanisms. You looked at the carbachol and the potassium chloride, and that enables you to know that this is a real effect. Sorry, I'm paraphrasing. And the 2 contractile stimuli. I mean, that's absolutely right. Of course, you could, in theory, if you just use potassium chloride, I expect it's theoretical rather than real. You could say, well, you're only achieving effect because my compound is binding to the potassium chloride. So it could be nothing to do with it. So by using 2, you know it's a beta-3 agonist effect that you're measuring. That's all it's saying. But it's a rat beta-3 agonist effect. And at 7:14, my lord has pointed out, actually I didn't mark that, And then at 716 that my learned friend went to, it is showing that mirabegron is a relatively full agonist of the rat beta-3 adrenoceptor. Only if we're in the veterinary surgery treating rats does that become a relevant consideration, because the common general knowledge, we've been to it, is that you can't extrapolate from the rats to the human in this case, particularly when you're looking for particular potency. So potent compounds in the rat turn out to be partial in the human, and you've seen that in Yamaguchi. Example 1 does not, I'm just looking at 717, someone's just handed me a note. What am I meant to read? Point to me. Example 1 does not provide any information regarding the method by which mirabegron achieves the above described bladder relaxant effects. Right, sorry, I'm not quite sure what point was. And then picking up just at 9.6, same document, I think my learning friend went to. The information provided by example 1 is not definitive evidence that mirabegron will relax human tissues either in vitro or in vivo. For example 1 would provide the skilled pharmacologist with reasonable scientific grounds to suppose that mirabegron would act as an agonist on the human beta-3 adrenoceptor. We already know that. We already know that it's old information that that mirabegron is a human selective beta-3 adrenoceptor. And that's why I need to then go to the important, and my learned friend makes a partial concession on this, which is important. He made it in his submission very fairly. When you actually get to look at the judge's analysis of 288, what the judge doesn't do is say you pick up 288 and you do not accept that mirabegron is a beta-3 selective, human beta-3 selective. That's old information, that is in the art that it is, and it's not being rejected as lacking credibility. And my learned friend accepted that it is disclosed as such, but what he points out is that there's no data, and one wouldn't know the potency and all those various other things he said. I'm paraphrasing him and he's frowning at me, but my learned friend heard his submissions. But the document as a whole is putting forward, I think there's any dispute, and there hasn't been any dispute, examples 1 to 6 as beta-3 selective agonists. What we don't know is the measure of testing. And, but of course, we know that examples 1 to 6 were made, and that is what the authors are saying. Now, that might be a more powerful point if my learned friend came along to this court, and it's a question of justifying a patent monopoly, and said, look, you know, they said it, no one would take that seriously. And what we've done is gone out and tested it. We've shown that mirabegron is indeed, in fact, a human selective beta-3 agonist. At least that would be an understandable case. My learned friend hasn't done that. Just hasn't done that at all. It's never been mirabegron, when he filed his patent, has never been near a human beta-3 agonist receptor. So on what basis, we say, can my learned friend possibly be justifying a 20-year monopoly in this field? And again, it comes back to what Lord Justice Jacob was saying in Pozzoli, that if something is put forward, even if it's considered unfeasible or impractical, it's still in the art. So the fact that mirabegron is a human beta-3 selective agonist is in the art. And the judge did not reject that outright, and he dealt with it at 167. And he says, my overall conclusion is that the skilled addressee would think that no safe conclusion could be reached over what testing had been done. That does not mean they would think that the teaching could not usefully progress. So the judge isn't saying, well, this teaching would be rejected. What testing the judge is referring to there, or progression, probably a combination of things. So is it the hope in a bladder assay? Is it the hope in a human bladder assay? Is it the hope in a clinical trial? The judge doesn't actually set out specifically what tests he had in mind in that passage. But the important point is the judge isn't rejecting, saying you look at this, you think, oh no, example 6, there's no basis for saying example 6 is a human selective beta-3 agonist. So, as we say, my learned friend then said, well, look, it's wrong to look at ASUS tech because it wasn't his client who was putting forward these arguments about lack of clinical utility or lack of clinical uncertainty. He wasn't putting them forward as lions in the path. With respect, that's a distinction without a difference. What is happening is the learned judge, leaving aside my learned friend submissions, the learned judge has rejected the obviousness case because of clinical uncertainty. And that is absolutely clear from what the learned judge has said at 194 through to 198 and also at 202. And indeed, every time the judge refers to testing, we have to bear in mind that the judge is concerned about the lack of clinical testing in addition to the lack of in vitro testing. So the learned judge said there was an issue here when he gave permission to appeal, and he understood that if the ASUS tech point applied, it may well be that this court would take a different view in relation to obviousness. The learned judge, and we say it's absolutely clear from the face of the judgment, the learned judge was placing reliance upon this general clinical uncertainty in the art. And it just, we say, just cannot be right as a matter of common sense and as a matter of patent law that you're entitled to leverage that, rely on that general clinical uncertainty to reject an attack of obviousness in this case, because you simply have not contributed to it. So the technical contribution case, my learned friend relies on, fails, because his contribution is, for two reasons, doing something very obvious, putting the drug into rats, and in any event, that gives you no information, no relevant information about potency in the human. Can I just give me 1 minute just to see if there's anything else? Oh yes, just also, again, just at 200, it's on the same point. This is dealing with the, that does not mean that the skilled addressing would positively think that mirabegron or the other examples in 288 would not work. So they're keeping an open mind. It's been put forward as a potent selective, and they're keeping an open, as a human selective, and they're keeping an open mind, which gives rise to the uncertainty referred to there, but they're not rejecting the teaching. And then at 202, just to again look at that once more, this is where the question to Astellas, counsel for Astellas, would be set that if a 288 disclosed mirabegron as an excellent potent specific beta-3 agonist, it would be obvious to try it for OAB, despite the condition not being mentioned. Initially accepted that it probably would be. Counsel for the claimants understandably sought to leverage this so as to argue all the claimants had to show that 288 did in fact disclose mirabegron. And then the judge goes on again to add in the general uncertainty around beta-3 agonism. Excuse me, Margot, can I just have 1 minute? Sorry. Okay, sorry, I got that point wrong when it was shown to me, which makes sense. We were on, sorry, I do apologise, supplemental bundle, tab 3, 716, and then we were looking at 717. And example 1 does not provide any information regarding the method by which mirabegron achieves the above described bladder relaxation effects. Given the preceding disclosure that mirabegron is a beta-3 agonist, that other beta-3 agonists are known to be able to cause bladder relaxation, plus the fact that skilled pharmacologists will consider it likely that mirabegron had been tested in the cell line experiments described in 607. 607 is 288. So, my lord, when it comes to justifying the plausibility case in this passage, they're pointing to 288. And that's what links it to beta-3. Given the preceding disclosure that mirabegron is a beta-3 agonist. So the witness is not saying, well, I believe it's a beta-3 agonist, and consistent with the judge's finding. That's the basis on which they're justifying this monopoly. And that's why we say, if you stand back and just say, well, what have they contributed? What has this patentee contributed? All they have taken is a known beta-3 agonist and put it in an irrelevant and immaterial assay. My lords and my lady, unless I can be of further assistance.
No, thank you very much. Thank you all for your submissions. We will take time for consideration. Once we have written our judgments, they will be distributed in the usual way in draft for correction of typographical errors only, not to re-argue the case. And as we all know, that will be done under embargo, which is to be strictly observed. In addition to correcting our typos, we will be grateful if at that stage you can try and agree a consequential order, which we hope you can do. If you can't, then please give us short submissions in writing and we will deal with it on paper.